So let me first thank all of you for accepting our invitation for this press meet. Uh, uh, this is to brief you about the national consultation, which is going to be held on 1st of February on the subject of electoral reforms, which all of you know that's a very important subject. The yes, please. Justice S.N. Kapoor is also a member of our commission. He is a retired judge of the Delhi High Court, and he is a senior member of the commission. Now, this issue of electoral reforms has been receiving the attention of the government, successive governments, the various commissions, etc. You want?
Okay. Is he audible?
I hope I'm audible. Yes, all right. All right. Much louder. Okay, all right. So there was a report made by the Law Commission in 1999 for suggesting certain electoral reforms. Some of the suggestions were accepted, but about the certain suggestions, particularly relating to the criminalization of politics, were not implemented. I mean, there was nothing was done by the government thereafter. Then there was a Constitutional Review Commission headed by Chief Justice Venkatachalaya. That commission also made certain recommendations. Again, nothing happened. The Election Commission of India has made certain suggestions in 2005. 2004, the Law Commission's suggestion was that those who were against whom a charge is framed for heinous offence, which are punishable with life imprisonment or death, should be disqualified from contesting the election. The similar suggestion was made by the Constitutional Review Committee, which said that, again, repeated that those persons, candidates against whom such charges of heinous offence is framed should not be allowed to contest the election. Then Election Commission said that it should be that if the candidate is facing a charge which is punishable against whom a charge is framed, which is punishable with 5 years or more, he should be disqualified. Then, I mean, these are the issues which are dealt with in the earlier report. Then when this reference was made to the government by the government to the Law Commission, a consultation paper was prepared, and you'll be all given the copies of the consultation paper. You see, the consultation paper, the first is deals with the criminalization of politics. Now, I can say that there are three models which may be considered. The first model is the existing model, where upon the conviction, the person gets disqualified automatically. Section 8(4) of the Representation of People's Act provided that a sitting or a sitting MLA is convicted, that he could file an appeal or revision, and pending the revision, this will not be revision or appeal, the disqualification will not be attracted. In Lily Thomas, the Supreme Court struck down Section 8(4) as unconstitutional. As a result, the disqualification would trigger on the conviction of MP or MLA. Then the second model is, which has been suggested by the Law Commission, by the Election Commission, and also by the Constitutional Review Committee. If charge is framed against that person by a competent court, then in respect of certain should be barred. Then there are other issues which we also considered, like what should be the duration for which the person should be disqualified if he is convicted. Today, as per Section 8, if the person is convicted, then he would be disqualified 6 years after that duration of the sentence, after he is released. Then there are some suggestions like he should be disqualified for permanently, or for a longer period. Then this next issue is about has been there for a long time, whether there should be all the candidates should be supported by the state funding to a certain extent. Then there is an issue of donations. I mean, a lot of clarity is needed on the donations given to the political parties. There is one issue about the filing. What is the effect of filing a false affidavit before the returning officer, making false disclosures? For example, I mean, you suppress your assets, or you suppress the fact that you are facing a criminal prosecution, or some charge has been framed against you. So the question is whether this could be a ground for setting aside his election, for disqualifying him. And also, presently there is is punishable with 6 months, whether it should be increased to 2 years. And then what about the scrutiny of these disclosures, at least in respect of the winning candidates? There is a suggestion that it should be those returns should be scrutinized by some body like either CAG or Income Tax Department. Then the next is, of course, about the electronic media and the print media. There are certain issues which are of course, all of you know about the issue of paid news, which is really where a space is given by a newspaper or a electronic media or the channel as a news, but it's really a promotional material. Then whether the media channels and the media houses should be asked to disclose their ownership of the media houses. Then the other aspect is, which was dealt with by the Delhi Lokayukta, whether the government should be a government could continue to highlight their advertisements, particularly when the elections are very near. So whether they should be no advertisements to be given about the achievements of the government for a period of 6 months from the date before the date of the election, and whether such violations of these guidelines should be punishable by law. Then enhancement of punishment for the electoral offences, I already dealt with that. The other problem is adjudication of election disputes. Today the fact is that the election disputes adjudication takes long time, and by the time an election petition is decided, mostly the entire period of that house comes to an end. Then there are other issues like whether a candidate should be allowed to contest in more than one constituency. Then there should be any official limit on the expenditure incurred by the candidate. Today I read in the newspaper that the Election Commission has suggested that it should be increased to 40 lakhs. Then there is also the issue of the election, furnishing the accounts of the election expenses. I'm just giving you the very broad. This is the spectrum of the different issues. Actually, we wanted to hold. We are in the process of holding a national consultation of all the issues. In December, an order was passed by the Honorable Supreme Court, making a reference to the Law Commission mainly on two issues. One is about the criminalization, and second is about the effect of the filing of a false affidavit, false disclosures, etc. Now, therefore, we decided to hold this one-day national consultation for only on these two issues. But Commission has to take a holistic view. So the Commission would be looking into the other aspects also. It is expected that the Commission will make a report to the Supreme Court on these two issues by sometime in mid of February, or in any case by end of February. The Supreme Court has fixed the matter on 8th of March. The other various aspects on which the Commission work is in progress, and we will be able to give the complete report preferably by mid of April, or in any case by end of April. When this consultation paper was submitted, was sent to all the political parties, I must tell you that the response was lukewarm. Only one political party, one major political party, that is Indian National Congress, responded to the question, our consultation paper, and there is one other party, a state party, a small political outfit, also responded. Responses were also given by some NGOs, some individuals, and we have analyzed those responses. And once the consultation process is over,
Some individual MPs.
Some individual MPs and MLAs have filed their responses, but the only one political party has taken cognizance of our consultation paper.
State party which responded?
A state party, just I'll tell you. Can you just get the name of the state party? Just I'll give you. And to be fair to the new political party, Aam Aadmi Party, this consultation paper was not sent to the Aam Aadmi Party because at that time it was not a recognized political party. I have personally written to the presidents of all the political parties, whether national or state. The commission has also invited the very distinguished civil society activists, NGOs. We have invited the statutory commissions. We have invited academicians. We have also invited the heads of certain law colleges. Some distinguished lawyers would act as the resource persons during this one-day meet on 1st of February. Justice B.P. Jeevan Reddy, a very distinguished former judge of the Supreme Court, and who headed the commission when this 99 report was made on electoral reforms, he would be inaugurating this national consultation one day. With this, I will ask my colleagues to just make some brief comments, and then I will take questions from you. Yes, Justice Kapoor, you want to say?
Would you like to say
something?
You are interested only in one point. How far the election shall be fair and free. A number of suggestions have come where some additional offences were sought to be added by the 99 Commission. Many of them have not been taken care of by the government. The Venkatachalaya Commission also suggested
sentences about your agenda.
Justice J.S. Verma has also submitted, and practically for all practical purposes, all those operations which were made by this commission way back in 1999 have been repeated, except there are some minor amendments here and there. Malimath Committee has also suggested the same thing. Then one very important development has taken place. Somebody suggested that there should be some matters relating to standards of public life. There is a Bolan standard, and which requires many things which may be of interest of many of you. How far we shall be able to consider, how far we shall be able to incorporate them on the pattern of United Kingdom.
Just take one.
It is a matter of time.
One thing I missed.
There are many more things. Say, the accounts of political parties. In RTI, some order has been passed, but they are shy to just follow. There was an attempt also.
This is just to add to that, and then we'll take questions after. The one this I told you about the two models. One is that the on charge conviction on framing of charge. There is a third model, which we also discussed in the consultation paper. That third model is establishment of an independent commission, a review commission, which to find whether the candidate is fit to contest the election. I mean, one might think it's a utopian idea, but it has happened in a way. I'm not saying it should be on the same lines, but in the recent elections in Pakistan, there was some such board. But that it's not only about the criminality, it's about the fitness of the candidate to represent the people. That also we have referred to that as a third model of establishing such a body. But that is yet to be discussed with the. No, that's as I said that this is only the beginning. We said that this is one of the ideas. With this, there will be some comments from.
Now let me directly come to your question. In fact, what happened was when we were preparing this consultation paper has been prepared taking into consideration kind of work which was already in existence, like different reports which the Honorable Chairperson has referred, the work which Justice Kapoor has referred, and all other kind of suggestions which were coming here and there, and the experiences of other jurisdictions. When we were taking all that into consideration, then this idea, right? I'm simply saying idea, and that is where, please mark, unfortunately, because I happen to be the chairman of the organizing committee of this consultation, and therefore, sir, I'm taking the liberty to make a cautionary note that this consultation which is being held is only to elicit views, opinions, agreements, disagreement, consensus from the people, so that it is their views which will give us wisdom in framing up our own suggestion. So we have merely thrown the idea, because idea is there. And what is the idea? That there are two models, conviction model, charge sheet model, but in various other parts of the world, there is a discussion going on that if morality and if ethicality of politics has to be risen and people have to be stopped with criminal record to come into the arena of parliament, then why should not there be some kind of screening even before? Though, now I will not say what, but though you are absolutely right, because this raises a serious question. Who are the people? Who are the people who will decide what standard should be fulfilled before you file your nomination? And who will decide what are those standards? Who will judge those standards? But these are the questions which we are raising before you, and which we are raising before the scholars, the academicians, the experts. We are saying this is an idea, right? And let's explore upon that idea. What happens? Maybe idea doesn't work.
This whatever you want to say about the other aspects.
The second thing, which with the permission of the chair, I like to say, because you are all here, and very rarely that we will have this kind of opportunity, right? And therefore, I'm taking a little liberty of going astray from today's agenda and mention to you that the election commission, the law commission, apart from these two parts of the consultation, is definitely going to hold a major national consultation on the entire consultation paper very soon. And apart from that, there are going to be many more consultations, because the commission has laid down a very ambitious, I'm using the word very ambitious, roadmap, a very ambitious agenda. And the agenda cuts across all paradigm of life, social, political, economic. Say, for example, we are talking of economic reforms, and therefore commission is now going to submit a report maybe in next 3 months on arbitration, international commercial arbitration. Commission is working on constitution of commercial divisions in each high court. Now, coming on social agenda, we are working on this debate about age of juvenile in the context of Nirbhaya, in the context of Shakti Mill, you know, the debate which has come up, we are working on that. This living relationship, we are working on that, right?
Right to housing.
And more than that, we are working on right to housing, a great human rights. Now, you know, 10 lives in just 3 weeks were lost in Delhi, and therefore right to housing. And therefore, you know, Commission has a holistic agenda, and we are only requesting you people to help us in interacting with us more and more. We will be very open in sharing information with you, number one. Number two, please do tell us where we are lacking, where we need to do more, and what we need to do more. Am I right, sir?
Yes, sir. There is one party you asked about, Welfare Party of India. Welfare Party of India, WPI. This is head office Delhi. It's Kerala and Karnataka. This is a regional registered political party, Welfare Party of India, but not recognized. Then there are total, I just give you the breakup. There were total 157 responses to the consultation paper, 123 from individuals, including some sitting MPs. Then the responses from the organizations were 21. The total number of commission and the government organizations responded to this responded to the consultation paper is 4. And I think I will give the exact number of members of parliament who responded. Was about 8 persons responded. 8. 4 from Lok Sabha and 4 from Rajya Sabha. And as I said, only 2 political parties responded. MPs names.
Even individual,
I will give you the list, the individual list. We have a list. Only 2 parties.
2 parties
responded.
Earlier consultation.
Earlier, now I have received letters from, I can say around 10 or 12 parties saying that they would be participating in the national consultation, and some of the major parties have shown interest in the discussions. Yes, they might come on first.
We will share with you all the information after the consultation is over. We will share with you who are the people who participated, how many people participated. Maybe within 48 hours of that conference, something will say.
Please, yes.
So this Saturday's consultation will be limited to criminalization and false
And yes.
As the reference was made to you by the Honorable.
There is some urgency in that, because the Supreme Court has fixed the matter on 8th of March. So the Commission has to expedite the process on these 2 issues and submit the report to the Supreme Court. Say we wish to submit the report by sometime in February.
So
yes.
February 1st consultation will be limited to these.
Yes, this is 2 aspects. We might discuss, because these are all linked. This even other issues are linked with the issue of criminalization. So perhaps even incidentally the other issues will also be discussed. I'm sure about that. Please.
Can you give us the abstract paper?
Yes, please. Yes, the
consultation paper.
Consultation paper we have given to you.
Other abstract papers.
No, what is today abstract paper is the consultation paper. But apart from that, if you are interested, would like to share with you the relevant portions of those reports, because those reports are very lengthy, some of the reports. But a relevant portion of the reports relating to these 2 issues would like to share with the media persons. So please, immediately after this press meet is over, Dr. Pawan Sharma will give you those.
You said that your report is going to come in April end. So that means in the coming Lok Sabha election we don't see anything.
No. This is just first. Let me clarify. This is only a recommendation. This commission only makes a recommendation. It's for the parliamentarians to pass the law. Some of the suggestions may be acceptable to them. Some of them ultimately depends upon the political class. The political class must take a call, and they take a decision whether we should improve the quality of our democracy, and we should also really think about the improving the present election system. Though the Election Commission has done a tremendous job, and really there is a lot of improvement in the way the elections are held, and it is lauded all over the world. but still, I mean, we can really try to improve the present enactment, which is Representation of People's Act. It's for the political class to respond to that.
So effectively, the next Lok Sabha will take a call, or maybe the next.
The next Lok Sabha will take a call on that.
But several commissions have given several recommendations in the last 10 years, and you have been saying the implementation part on the part of the government has been minimal.
No, there is
so
a.
What is the point in sending?
Oh, it's not. No. That's not correct. Actually, it's not that at some stage, because the government has not responded or the political class has not responded, the commission should, because when 1999 report was made, the issues were different. Today there are completely new set of issues. This is one aspect. Secondly, you should see the change in the last 1 year about the people's perception about their expectations from the political parties. I mean, I'm hopeful with the incident, what happened in last elections in Delhi and the other places, and perhaps the response of the political parties on the issue of the criminalization would be different. This is my expectation, and there are different recommendations from different commissions. Now, I can just explain to you there are nuances are very interesting. Now, there is a fear that if you provide that a person would be disqualified after framing a charge against him by the court, he might be falsely implicated. A political party in power might take advantage of that, and then is likely to be misused. So how you deal with that situation? The other aspect, all right, I mean, there is a suggestion that if one suggestion is that it should be charge ought to have been framed 1 year before the election, so that there should not be some case created only to disqualify a person. But think about it. What about the sitting MPs and MLAs? If the charge is framed against them, are we going to say the same thing in view of Lily Thomas' judgment? They will be disqualified the moment the charge is framed against them. What happens to every time charge is framed against a person? Are you going to hold the elections because he would be disqualified? At the time of framing of the charge, an accused is not entitled to produce any material. As per the established law of this country, the charge is framed only on the basis of the material produced by the prosecution. Then the other aspect is about the judicial. It takes long time to finish a matter. So what are the safeguards to deal with this with these aspects? It's really a very complex exercise, particularly in view of the Lily Thomas case, where the Supreme Court said that if you provide a disqualification for a person aspiring to be member of the legislature, same disqualification should apply to the sitting MP and MLA. So how you tackle with this situation? So these are the challenges before us, and I must tell you that the government has also prepared some paper. At some stage, it was sent to us. We will know about the official position taken by different political parties. Would be only on 1st, but that's we have to wait till the end. And hopefully, I mean, you are right. I mean, in the past, in spite of several recommendations, nothing has happened. But hopefully, in this, with the new elections coming round the corner, Supreme Court is actively looking into the matter. There will be some change in the situation.
What do you think on ban on opinion polls?
No, this is not the issue which we had taken up. It's a very complex issue, and really, when you talk of ban on opinion poll, we must be very clear about Article 91A. That's a very, very precious right, which is what as the Supreme Court has observed, that it is the most prominent right amongst the fundamental rights. So we have to, and then what is the reasonable of such measure, which is if at all it is taken. So that we have not. That's not part of the consultation paper, but hopefully, I mean, at this stage there are some priorities. But hopefully, if it is referred to us, I mean, we'll simply look into that, or we might take a look at it on the suo moto. But I feel that it's a 19(1)(a). Personally speaking, I regard this as a something cornerstone of the Constitution. So we look. I won't be able to say either way.
What about right to recall?
A right to recall is also the part of the consultation paper. This is also one of the suggestions which is taking around for a long time. Now, right to recall is really, which is not. There is some misunderstanding about the Supreme Court decision. I'm sorry. My apology. I mixed it up with Nota. I'm sorry. I mixed it up. Right to recall is also one of the. Right to recall is only in some few countries it is existing, and it is working very well because of the perhaps that those countries are in a much advanced stage. But that's an issue which will have to be debated over a long time. I thought you asked about Nota, which is partially recognized by the Supreme Court.
Will you revisit the Nota option?
Yes, of course we are going to not revisit. I mean, Nota option was originally there had to be disclosure. You had to fill up the form, but the option which is given by the Supreme Court is with confidentiality.
Suppose there are 100 voters and 90
absolutely right. This is
will it be fair to
this is Nota. You are right. Absolutely right. This is Nota really. That if those votes are in excess of the votes polled by not by all the candidates, but the winning candidate, then the election has to be cancelled. So this is really the effect of Nota. But several questions are put before us. For instance, one question someone asked me, what about the areas which are affected by, say, Naxal affected areas, and the entire population is forced to only press Nota. Sometimes the election would not be allowed to happen. I'm not saying that this is a correct assessment, because in spite of the Naxal dictate that the people should not vote, there was a huge, good percent turnout for the elections in last 4 state assemblies. So it's not that so these are issues will have to be debated, and that we propose to do once we finish with this consultation. And there will be another consultation on the
consultation paper itself. That apart from this, all other issues.
Yes, we have also invited issues from the papers, issues from the political parties. If somebody, and we have received some papers from some NGOs, and we'll be looking into all the aspects. I can assure you one thing. What would happen to our report is a matter of speculation, but would like to look into all the aspects and submit a comprehensive report, say by April or first week of May. That's our target. It's a difficult task. You have to pardon my Hindi. I'm not very.
So, 1 second, sir. राजू, क्या आपने ये मीडिया ब्रीफिंग बुलाई है?
हाँ.
क्या जानकारी आप शेयर करना चाहते हैं?
इलेक्शन लॉ कमीशन ने जो ये कंसल्टेशन पेपर सभी राजकीय दलों को भेजा है, ये कंसल्टेशन पेपर में बहुत सारे इश्यूज हैं. क्रिमिनलाइजेशन ऑफ पॉलिटिक्स, ये पेड न्यूज़ का इशू है, उसके बाद में फंडिंग का इशू है, और ये पॉलिटिकल पार्टीज़ को डोनेशन देते हैं, इनका इशू है, और ये जो एफिडेविट झूठा एफिडेविट सब जो किसी ने किया, तो वो उसका नतीजा क्या होगा, उसका इलेक्शन ही ये इलेक्शन परिणाम, इलेक्शन रद्द हो सकता है क्या, या उसको सज़ा जो आज 6 महीने है वो इंक्रीज बढ़ाई जाए, और ये जो एफिडेविट जो है वो किसी स्टैट्यूटरी एजेंसी से उसकी स्क्रूटिनी करवाई जाए, जैसे CAG की तरफ, CAG को ये भेज सकते हैं या इनकम टैक्स डिपार्टमेंट को भेज सकते हैं. मेरा खुद का ये कहना है कि इसको CAG को भेजना चाहिए, क्योंकि वहाँ ये सभी कैंडिडेट्स का तो हो नहीं सकता है, लेकिन कम से कम विनिंग कैंडिडेट्स की तो उनकी जो डिक्लेरेशन है उसकी स्क्रूटिनी होनी चाहिए। तो ये भी एक सवाल है कि प्रिंट मीडिया का भी सवाल है। ये मीडिया पे बहुत सारे अभी मीडिया हाउसेस है या चैनल्स है, उनकी ओनरशिप है, वो डिस्क्लोज़ करनी चाहिए क्या? किसी ने ये भी सवाल उठाया कि ये ओपिनियन पोल्स होने चाहिए कि नहीं। ये तो सवाल अभी हम उसमें ये हमारे ये कंसल्टेशन पेपर पे नहीं है, लेकिन शायद उसके बारे में भी कमीशन उसमें पेड न्यूज़, ये जो पेड न्यूज़ है वो एक्चुअली अपनी स्पेस या चैनल दे देता है या न्यूज़पेपर देता है, ये किसी पॉलिटिकल पार्टी को या इंडिविजुअल कैंडिडेट को, और ये एक्चुअली एडवर्टाइजमेंट जैसा होता है जिसको न्यूज़ करके पास किया जाता है। तो उसके लिए एक माजी मुख्यमंत्री है, उनका एक मुकदमा सुप्रीम कोर्ट में चला है, तो ये भी एक इशू अभी ये है। और ये जो ऑफेंसेस है उसमें अगर कन्विक्शन हो गया किसी ऑफेंस में तो वो डिस्क्वालिफिकेशन है जो वो परमानेंट डिबार हो जाएगी क्या? ये भी कुछ इश्यूज़ है। तो ये बहुत सारे इश्यूज जो है वो तो कमीशन को उसमें उसके सभी के जो रिस्पांस है आ गए हैं। पॉलिटिकल पार्टीज़ में कोई 2 ही पार्टीज़ ने हमें रिस्पॉन्सेस भेजे थे, उसमें एक कांग्रेस पार्टी है और दूसरी WPI पार्टी है, कोई वेलफेयर पार्टी ऑफ इंडिया, और कोई MPs ने भी उनको इंडिविजुअली रिस्पॉन्ड किया है। तो उसकी तो स्क्रूटिनी हो गई है। सुप्रीम कोर्ट ने एक आदेश दिया है कि लॉ कमीशन को कहा है कि क्रिमिनलाइजेशन के बारे में और ये जो फॉल्स एफिडेविट है उसके बारे में एक रिपोर्ट देने के लिए, तो वो रिपोर्ट कमीशन पहले फरवरी में सबमिट कर दी जाएगी वो रिपोर्ट, और उसके बाद में जो बाकी के इश्यूज़ है उसके कॉम्प्रिहेंसिव रिपोर्ट अप्रैल एंड तक हो जाएगी।
एक पॉइंट से खाली की ये चर्चा हो रही है कि चुनाव आयोग चाहता है कि जो फंडिंग है कि ये जो सीलिंग्स थी लोकसभा में 25 लाख तक खर्च कर सकते हैं।
प्रैक्टिकल तो ये है कि कॉन्स्टिट्यूंसी जितनी वोटर्स की संख्या है वो तो उसमें तो ये 25 लाख तो बहुत कम हो जाता है, लेकिन तो उसमें तो ये विचार करना पड़ेगा कि स्टेट फंडिंग कुछ आ सकता है क्या उसमें। और जो इलेक्शन कमीशन का अभी सुझाव है वो 40 या 50 लाख तक इंक्रीज़ करे, वो तो अभी ये एक बार ये क्रिमिनलिटी के बारे में एक बार ये कंसल्टेशन ये बातचीत हो जाएगी, तो उसके बाद में इमीडिएटली ये इशू भी ले जाएगी। इस पे यस डिस्कस
इसके साथ में एक और पॉइंट है, वेदर बाय इंक्रीजिंग वी शैल
हिंदी में
अगर मान लीजिए ये 40 लाख से 60 लाख या 1 करोड़ या 2 करोड़ या 3 करोड़ कर दी जाए, तो आप में से कितने लोग इलेक्शन लड़ पाएंगे? इट इज नॉट ए प्रोसेस टू आउस्टर द आम आदमी फ्रॉम कंटेस्टिंग इलेक्शन।
हिंदी में बोलो।
सॉरी,
महंगा होना नहीं चाहिए।
बहुत सारे लोग चुनाव नहीं लड़ पाए।
पर इसमें एक बात और भी आ सकती है।
अब इसका अल्टरनेटिव क्या हो सकता है? एक अल्टरनेटिव होता है गवर्नमेंट फंडिंग करे, और इलेक्शन कमीशन ने किसी का सजेस्ट भी किया था, गोस्वामी कमेटी ने भी सजेस्ट किया था, लेकिन क्या गया डॉट डॉट
नहीं। लेकिन इसके अंदर एक और बात भी हो सकती है कि क्या कॉन्स्टिट्यूएंसीज को छोटा किया जाए, क्योंकि अगर एक कॉन्स्टिट्यूएंसी इतने स्क्वायर माइल्स के अंदर घूमती।
जेंटलमैन केजरीवाल, अदर पार्टीज BJP and other parties say no is less.
57% नहीं सर, 50% से कम कर दीजिए।
No, that's a individual matter. I mean, the commission would not like to comment on that. इस पे हम नहीं कोई कमेंट्स कर सकते, हम इसके ये दिखाए। Thank you very much. Thank you. Yes, sure. Thank you.
नहीं। ओ प्लीज देयर इज अ कंफ्यूजन। जो मेरे से एक सवाल पूछा गया है,
All of them personally, all the state parties and all the national parties are invited for this consultation.
Recognized and unrecognized.
Recognized, of course we unrecognized we really don't know. हाँ
नहीं, ये दो का
रिस्पॉन्स कंसल्टेशन पेपर, पहले कंसल्टेशन पेपर को आया है। हाँ जी। वो इसका काफी पॉजिटिव रिस्पॉन्स है, क्योंकि काफ़ी पार्टीज ने लिखा है कि वो पार्टिसिपेट करेंगे।
बल्कि हम तो चाहेंगे कि सर आप सब लोग निमंत्रित हैं।
हाँ, सो सभी लोग अभी मीडिया को हम अभी this we take this opportunity to extend our invitation to you. I mean, it will there are 6 or 7 lawyers. I mean, Mr. Nariman, Mr. Surabji, and several others. They would come there as resource persons. So there's it's a amalgam of different segments. I mean, there will be academicians. We have given you the agenda. We have also given you the consultation paper.
Abstract paper or
The papers which I will ask Dr. Pawan Sharma to give it to you. Yes. Just he bought.